Good afternoon, and welcome to a very special edition of the Family Law Section's Facebook Live with Andrea Reid. My name is Amber Kornreich, and I'm a family lawyer in Miami, Florida. We'd like to take a moment to congratulate all of the Family Law Section's new leadership, including new chair Sarah Kay, and all of the recent section award winners. We'd like to also remind you about the upcoming 2023 Trial Advocacy Seminar taking place July 13th through 16th, 2023 in Orlando, Florida, and the 2023 Legislative Update taking place on July 20th at noon that Andrea will tell us more about. Please remember to follow the Family Law Section on Facebook, Instagram, and Twitter to stay up to date with all of the section's happenings. It's my pleasure to now introduce today's speaker, Andrea Reid. Andrea is an experienced litigator at the Reid Law Group. She's a member of the Family Law Section's Executive Council and co-chair of the section's Legislative Committee. She served in numerous leadership positions within the section and the Florida Bar, and has been actively involved with lobbying the Florida legislature on the most important issues affecting Florida's families. She's a role model to so many members of the section, and we're so pleased to have her with us today to discuss the new legislation. So thank you, Andrea.
Thank you. It's a pleasure to be here.
Of course. Thank you for coming. So Andrea, many of our members have heard that the governor just signed new changes to Florida Statute 6113. So let's start with one of the biggest. Is it true that there's now a 50-50 equal time sharing presumption?
That's true. So House Bill 1301 was signed by the governor yesterday, late evening, Tuesday. And that particular bill is pretty monumentous in the fact that it has now created a presumption that 50-50 equal time sharing is in the best interest of children. There's some safeguards to that, though. So this bill, unlike all of the bills that we had seen in the past in the legislature, this bill takes the best interest of the children to heart and also requires that the court make written findings of fact regarding all of the factors in 6113 sections A through T. So though there now is a presumption that equal time sharing is in the best interest of the children, there's also a requirement that the court evaluate the best interest factors in making the determination. Now, a parent can overcome the presumption. This is a rebuttable presumption of equal time sharing, and it can be overcome by a preponderance of the evidence. And we have seen preponderance of the evidence in a couple of different places in the family law statute. As you know, in order to overcome relocation, you have to prove it by a preponderance of preponderance of the evidence with best interest. We've seen preponderance of the evidence when it comes to donative intent. And we've seen preponderance of the evidence in the adoption, whether or not an adoption is in the best interest of a child. So this is not a standard of evidence that's unfamiliar to any of us as family law practitioners, and it is the lowest standard of evidence. So yes, we have a presumption for equal time sharing, but what does that mean overall? Is it a big difference? We're not sure, because what we do know is that sure, the court may be starting from 50-50, but our judges still have an obligation to consider all of the factors under 6113 before making any decision regarding a time sharing schedule.
Wow, Andrea, that's a big change. So there's changes to specific written findings of fact. So what should our members know about findings of fact under the new law?
Right. So it goes in lockstep with the case law we've been seeing over time leading up to this change actually being put into statute, which is a requirement that all of the factors have written findings. So what I would encourage practitioners to do is when you're preparing your final judgments for your judges, make sure that you're addressing the factors in writing in your final judgment.
Excellent. So we understand that the law also made changes to modifying parenting plans. So can you address some of those changes?
Yeah, so there's two, right? So the first one is that the legislature has removed the word unanticipated from the standard for modification. So as we all know, traditionally, we've had to prove an unanticipated substantial material change in circumstances in order to modify a time sharing or parenting plan. The word anticipated has been removed from that. I suspect that the legislature's intent was to address those cases that have been coming up in recent years where there's a positive change in circumstance for a member of the family. For example, a father who previously didn't have a home of his own has now gotten a home of his own. And even though we knew at the time of final judgment that that was an anticipated event, that would be positive, it prevented modification because it was in fact anticipated. So we're seeing the elimination of the word unanticipated from that standard. The other change is such a very specific thing. So if a parent who is residing 50 miles away, outside of 50 miles from where the child is currently residing, moves to within 50 miles of where the child is currently residing, that is an automatic modification. So they don't have to prove a substantial change in circumstance because the statute says that event in and of itself is a substantial change in circumstance. You pass go, you go to your modification. So that's a pretty specific addition to this bill. And I think that it was intended to address some concerns about our service members coming back into a 50-mile radius of their children and having the burden of proving a substantial material change in circumstance.
Thank you, Andrea. So there's so much to know here. So if members want to learn more about these changes and other legislative updates, what recommendations do you have for them?
So first things first, dig into the statute, read it. The bill itself is only about 9 pages, and there are very few changes within the bill. It's strike through and underline for the additions, and it's pretty easy to read. You can find it online. Again, it's House Bill 1301. Now, the other thing is I would invite everybody on July 20th to join the family law section in a CLE where my partner in crime on the legislation committee, Magistrate Beth Luna, and I, and our chair, Sarah Kay, as our moderator, will be presenting on the legislative changes. So there have been some big legislative changes. Everybody's sitting on pins and needles as you and I record this today, waiting to hear about the alimony bill. There was a change to the paternity statute. There's a change to support for dependent adult children. There are numerous changes to 6113. And I think that it's going to be a great time to hear from Beth and I about all of the legislative changes. It's been a pretty historical year in legislation for family law, for Chapter 61, Chapter 742. There was Grayson's Law, which changes some things to domestic violence. So I would encourage everybody, July 20th, from 12 to 2, block it off, join Beth and I and Sarah Kay for that lunch and learn. And we look forward to seeing everybody.
Well, thank you so much, Andrea, for sharing this great information and your time today. We'll make sure that that link to register is in the comments. And thanks again.
Thanks so much. Have a good night.
Have a good one.